So what visa options are available to founders? Typically, I like to advise that founders in particular plan ahead, because visa for founders are challenging, but very doable. So some of the visas that are available are the E2 visa, the L visa, the O1A, and sometimes, when appropriate, the H1B visa. So let's talk a little bit about the E2 visa. An E2 visa is an investor visa, and you have to be a national of a country that participates in our treaty, the E2 treaty. Some of the key metrics of that visa are that you are coming to the U.S. to open up a business, a company, or purchase an existing company, and you're going to invest some funds into that business. The typical amount that's pretty industry standard is about $100,000 to $150,000 US dollars, and I typically like for the client to have spent between $10,000 to $25,000 of that initial investment prior to going to the consulate for their interview. We also want you to build a company that's not marginal, and what that means is a company that is going to have growth and support more than just the one foreign national. If the investment is too high for a founder to use the E2, we typically will look at the O1 visa or the L1. The O1A visa is for individuals with extraordinary ability in business and arts and science. Typically where we use O1A visas for founders is in business. So for example, a founder who starts his company, his or her company in their home country, and that company receives a lot of press, or that founder has some patents, or the founder or the executive team, or it's important to remember we can also do this for other essential employees within the company. Then we can actually apply for the O1A. And we have been using the O1A in the past couple of years, in particular for founders, because of the type of landscape that we're working with for U.S. immigration. Then we're going to move on to the L1A and the L1B. This visa is an intercompany transfer visa for executives and managers, that's the L1A, and the L1B is for specialized knowledge individuals. The requirements for this visa are that the company has a qualifying relationship, the foreign company has a qualifying relationship with the U.S., the new U.S. entity or the existing U.S. entity, and that the applicant for the visa has worked for the company, the foreign company, for at least 365 days. In addition to that, for the either the executive or managerial, or for the specialized knowledge individual, we must prove that that individual has worked in that particular capacity for at least 365 days. Sometimes the L1 can be a little bit difficult for a founder to use, either because of the timing of the incorporation of the business in their home country, or for just the sheer fact there's not a lot of evidence available for them to pull from. Whereas the O1A that we just spoke about, that is really focused on the individual themselves and not necessarily the company.